We're going to move to further debate. I recognize the member for Oshawa.
Thank you very much, Speaker, and I am very pleased to be able to stand in my place as the proud member representing Oshawa in this House. And it is actually it's an important conversation that we've been having. We're discussing Bill 157, the so-called Enhancing Access to Justice Act. This is a significantly sized bill in that it has 19 schedules, that it has 19 separate areas of focus in this bill. It is, it's possible to agree with lots of stuff that the government does without, and still have more to pull, because this is a missed opportunity. When you title a bill Enhancing Access to Justice Act, I think people might get their hopes up, especially those thousands and thousands of people who are standing in a queue or waiting, waiting for their day in court, so to speak, waiting for their tribunal hearing, hoping that they can have legal support or some guidance through our chaotic systems. And I say chaotic not to undermine them, but I think right now we've seen such a degradation in our systems, and I'll speak about that later, specifically our tribunal system, that we're at a point that if the government doesn't really listen to the folks who are giving them good advice on how to make things better, we're going to see things get really bad, even worse than they are now, and quickly. So, Speaker, what we have here, we have a bill, and I think I'm going to stand here as a New Democrat and say, hopefully all of us, but certainly those of us on this side, believe that everyone in Ontario deserves equal access to justice. There have been years of this government, the government before, which was the same government, the government before that, which some days I feel like it's the same government, have underfunded, right? Underfunded, cut programs that have left Ontario's court system in crisis. There are unprecedented delays and a massive court case backlog. We have seen cases, and the member who serves as our justice critic, that member shared some very tough to listen to stories about people whose cases have not had their day in court, and the perpetrators of very violent and terrible things, acts against them, have been allowed to walk free, and that speaks to the problem in our court system. Because cases, including those involving the sexual assault of a minor, impaired driving, other serious violent acts, are being thrown out because they're moving too slowly through the courts. Many courtrooms are closed due to staffing shortages, others due to the poor states of repair. Some are actually physically falling apart. So there's a range of challenges. The Conservatives have dramatically cut legal aid and made it even harder for many Ontarians to access justice. So as I said, there are 19 schedules in this bill, and unfortunately, they fail to address some of the biggest challenges. Not to say that they don't address some of the pieces, and there are some, I will say, random, and that's not even to diminish them, but there's kind of a smattering of changes, and I'm curious to know, who had requested some of them, because when we hear stakeholder groups across the province clamoring for change and support, those big issues are not addressed in this piece of legislation. So I would say the bill is disappointing. It touches on many issues that desperately need improvement, but it doesn't meet the moment to address and fix those issues, issues that the bill mentions, right? So recognizes that people are talking about it, but here we don't see the fixes. I will say, as I mentioned, that our justice system is in crisis. A case having to do with sexual assault of a minor, and I said drunk driving, and other violence, they're moving too slowly through the court system, so they have actually been thrown out, sometimes due to closed courtrooms. And, Speaker, I will say that the minister responsible for this file this is not his first day. You know, this is a minister that I will give credit where credit is due, and there are some members over there that I wouldn't be so quick to say this, but this particular minister is bright and capable of understanding these challenges. And so I do believe that the minister knows how complicated these challenges are, and we would hope that by this point in the journey with this government that we were further along to fixing them, especially when many solutions have been offered. So the government has been making some financial investments, for example, in the tribunal system, and yet it's so bad. It's the worst that we've seen it. So money isn't quite enough when we're dealing with systemic challenges. Speaker, one of the things that I would like to talk about as we're standing here debating a bill called Enhancing Access to Justice Act, folks in our community right now have been seized with the story of the Premier now quadrupling down. Is it still only quadrupling? Yeah. Has he quintupled yet?
Quintuple
no.
Hasn't
okay.
Happened.
So, but doubling down, tripling down, quadrupling down on like-minded judges and the appointment of judges. So I'm going to read here. I'm going to read here from a piece. Law Times. Legal groups voice concerns over, I'll say Premier, repeatedly saying he wants, quote, like-minded judges. Advocates Group, Criminal Lawyers Association, CCLA, and FOLA all fired back at the Premier. Quote, several legal organizations have spoken out about Ontario Premier repeated statements since last Friday that he wants the judicial appointment process to produce judges who are ideologically aligned with his progressive conservative government. Quote, we got elected to get like-minded people in appointments, he said. Another quote from the Premier is, quote, I am not going to appoint some NDP or some Liberal. I have made it very clear where I stand with judges, end quote. Going on, he reiterated his support for like-minded judges and said, quote, we're going to triple down on making sure communities are safe. I'm sick and tired of judges letting these people out on bail. We're going to hire tough judges. That's what we're doing, end quote. Well, Speaker, the Criminal Lawyers Association reminds this government that, quote, judicial independence is a cornerstone of our constitutional democracy. We echo the concerns of other Ontario legal organizations and urge your government to appoint qualified, principled, impartial judges of the highest caliber, regardless of political affiliation. Judges must be free to make fair and impartial decisions, often difficult decisions, without concern for whether or not their rulings align with the government of the day, end quote. Also at the press conference where the Premier made the initial comments, he said judges were releasing too many criminal suspects on bail while their cases proceeded through the court system. He said that in every appointment he's looking for, quote, tough judges, tough JPs to keep guys in jail, end quote. Well, the Advocates Society's letter said that, and I'm quoting this directly, the Advocate Society's letter said that a judge's role is to apply the law to the facts of the case, not to implement government policies, such as being soft or tough on crime. And, quote, to suggest otherwise violates the separation of powers ingrained in Canada's constitutional order and undermines the judiciary's independence as a third equal branch of government, end quote, said the letter. Also, in the view of the CCLA, it's imperative that judicial appointments remain nonpartisan and based on merit to ensure that the charter right to bail is implemented in a way that upholds the rule of law, end quote. We've been sharing a lot of the reaction of the legal community in this room. I'll say a favorite of mine is this, that the chair of the Federation of Ontario Legal Associations, Douglas Judson, had said, or for the legal community, the Premier's comments reflect a, quote, fundamental and frankly juvenile misapprehension of the importance of judicial independence to democracy. So in their statement, and I don't know whether I say FOLA or FOLA's statement on the Premier's comments, the organization urged the government to, quote, depoliticize and return independence. Speaker, what I found interesting about this story, beyond that it's upsetting and that, you know, meddling in the judicial side of things is not what we're supposed to do, people in the community really don't like this one. Like, on folks who may or may not generally share their politics or have political opinions in their everyday, because most people are too busy to tune into what happens in this space and place. A lot of folks out there are like, what are they doing? So they've pushed a button here. Speaker, I will also return to what I had been talking about with the experience of people in our community, those backlogs, the challenges. Here's a letter that I got from David. And David wrote, "Hello, Jennifer. I have been trying to get an answer as to why the courthouse service counter hours are only 9 to 11 and 2 to 4. I got to the courthouse today before 1:30 p.m. and there are already 12 people waiting for the counter to reopen at 2. But the stats won't show the demand for this service because we all have to wait until 15 minutes before the counter opens to be able to get our ticket to wait for our turn to be served. Isn't access to justice a right in Ontario?" And that's David. And that is maybe a small piece of the big picture, but this is how this individual is experiencing it, standing in line to get help, and where's the help, right? And where's the answer to where's the help? This is, I'm sharing this, I had reached out, of course, to the Durham Community Legal Clinic. And our legal clinics in our communities, I imagine that all MPPs in this space have them on speed dial. We're all connected to the legal clinics because we do our best to serve people who come through our door, and many folks, have many needs, right? And we don't give legal advice, except the Premier, but the rest of us don't give legal advice. So, as a preliminary point, I want to say it's important to note that community legal clinics are funded out of the general legal aid budget. They're not funded separately. So the cuts of 2019 to the Legal Aid Ontario budget impacted clinics as well as other legal aid services. And these are some points shared. We'd reached out to Patrick Gillespie, the executive director locally, but he said in 2019 the provincial government cut its contribution to Legal Aid Ontario by 1/3, approximately $130 million. Clinics continue to strain due to underfunding. Particularly, clinics face a recruitment and retention crisis regarding their staff. Chronic underfunding is making it impossible for community clinics to hire and retain staff, particularly lawyers who can be better compensated elsewhere. Clinics have been asking the provincial government and Legal Aid Ontario for an infusion of additional resources to respond to this crisis. The Legal Aid Ontario financial eligibility requirement is too low, forcing us to turn away many clients in need. However, the challenges with recruitment and retention poses a problem in addressing that need, even if the financial eligibility rate was increased. Making it local, but probably you could extrapolate this to other communities in the province. Durham Region is one of the largest catchment areas in the province with an ever-growing population and service need. But it is served by only one clinic, when much smaller areas have many more. And as he has shared, the move by the government and their, quote, digital-first program to keep Landlord and Tenant Board tribunals online has had a negative impact on marginalized elderly and low-income clients. This approach favors those who can afford technology. Yeah, and I mean, technology as an option, great. Technology as that's all you're allowed to get? No. And we all are hearing that, and we know this. Okay, here's a letter. This is a tenant in my community. Her name is Jackie. I'm a 70-year-old resident of Oshawa who has lived in a basement unit of a 5-plex in Oshawa. I have lived here for almost 17 years. I always pay my rent on time. Apartment is immaculate. I've done all painting of walls and ceilings, backsplash, put down new flooring, all on my own and on my own dime. I have 3 cats, 2 very senior that have always lived here and go outside with a cat door because there's a field next door and they love to go to our and they love to go out, just lay on my front lawn. I am a perfect tenant and have been helpful all through the years because the landlord is rarely here, and I'm the one to contact him if pipes burst, washing machine breaks, etc. I was given this N12 notice in September. I'm going to move forward here. I did not move out of my apartment, and the hearing for the tribunal has been scheduled for a date in April through Zoom, which I have no idea about. Just to replay, Jackie's 70 and is trying to live her life. I will continue. Jackie has shared, this is ridiculous and inhumane. What can be done about this? I will have to retain a lawyer for the tribunal meeting as I know nothing about Zoom meetings and I will have added expense for a lawyer. I feel I have grounds to fight this. Is there anything that can be done that you could advise or help me with? I have been sick with worry and stress for 6 months now, living in limbo. It's affecting my sleep, my livelihood, my job. Yes, I still work full-time. Thank you, says Jackie. Lots of tenants with lots of experiences out there, and we got a lot of people waiting in line at that tribunal. This is a portion of a significant 4-pager, and this is from Roxanne, and she has written to me as an independent small landlord of one home / unit in regards to the Landlord Tenant Board. She raises issues of lengthy waits of over a year, continued suffering by small landlords, abuse of the system, non-paying tenants allowed to appeal an eviction after failing to follow through on an order, tenants living in unsuitable homes that landlords refuse to repair, sheriffs are backed up for 2 months. As you are all aware, the list goes on. And I'm pulling just some highlights from Roxanne because in the interest of time. I own a home in Oshawa and have tenants occupying the premises. The arrears are now over $25,000. The next hearing was January 23rd for an issue that was already granted a resolution with consequences. Need I even say is a time slot that could have been used for someone who actually needs an adjudicator to sort out a serious issue. For example, how many tenants are suffering at the hands of landlords that don't know their legal obligations or are deliberately making the life of a good tenant difficult in hopes they will just move out so the landlord can now have new tenants, new lease, and charge more? These tenants are waiting upwards of 2 years for resolution to their problems, while non-paying tenants get appeals and second and third hearing dates and are allowed to continue abuse of the service. Roxanne says thousands of landlords losing their savings, their properties, their shirts, and going into serious debt to hang on to a property they worked hard to acquire, while a tenant can stay in a unit and pay nothing till it finally gets to the point where a landlord now has to spend more money they already don't have to pay for a sheriff and have them physically removed. Granted, the sheriff is a last resort and not always needed, but the 4 to 6 week wait for a sheriff tells me that it is used frequently enough for those tenants that refuse to leave. Man, and I feel for people who are living in this kind of chaos and limbo. The sheriff's circumstance, that's 2 months that she has to wait for that. There's only one in Oshawa, apparently. And it says, I am now approaching 2 years of stress and waiting. And that's Roxanne. Roxanne was speaking as, somebody who has one unit that they rent out, trying to make ends meet in a community. And a lot of us have small landlords who are our neighbours. And we're in a crisis of we don't have enough housing. If this government can't fix the tribunal, how many people are going to leave the system and say, I'm not renting my basement anymore? And I'm basically out of time, but I will, because I had this whole report highlighted and ready to go from Tribunal Watch Ontario, but I will read this bit that they have said. There's little justice to be found for Ontarians who have to turn to Ontario's busiest tribunal, the Landlord and Tenant Board. The LTB has been failing badly since 2019, when the current government began removing its experienced adjudicators and moved the LTB under the leadership of Tribunals Ontario, a mega cluster of tribunals. The deplorable situation at the LTB is not getting better. According to the most recent annual report from Tribunals Ontario, the situation is getting worse. The backlog of LTB applications has grown to over 53,000. Despite increased funding and more staff and more adjudicators than ever before, the delays remain crushing, and the number of cases resolved each year has continued to drop. Goes on, and it says, this begs the question, what is going wrong at the LTB. I got 9 pages to tell this government what is going wrong at the LTB, but I'd be willing to bet that the minister and the ministry already know, and that is why we should have seen those solutions in this piece of legislation or action from this government. Thank you, Speaker.
Thank you. We're going to move to questions for the member of Oshawa. The member for Hamilton West and Castor Dundas.
Thank you very much. Thank you to the member for Oshawa. You talked about the backlog in the courts and the delay, and that the government likes to say that it's because we don't have tough-minded judges, but in fact it is the delay in the court system. The most poignant, there's a number of poignant stories, but I want to share again the story of Emily, who was a young woman who was sexually assaulted in her home, and she bravely took her rapist to court, despite how difficult we can imagine that is, only to have her case delayed again, and then finally it was thrown out because it passed the 18-month timeline. To the member from Oshawa, can you imagine the indescribable feeling of being violated not once but twice by the system, and that a government who puts this bill forward and doesn't put anything in there to make sure that something like this does not happen again in the province of Ontario?
Thank you. The member for Oshawa.
Thank you. And for women like Emily, and I say women because there are a lot of women who are struggling with even finding the, I hesitate to say strength, but to have faith in the system, to even enter the system, to come forward with an accusation and step into the system. And then to have gone all the way through it and to then not get the day in court, to know that that her abuser or that the perpetrator had gone free. I don't know the words to say to someone like Emily, but I do have the words to say to this government, and that is, Emily is not an anomaly. There are a lot of folks out there who deserve justice, not only access to justice, and what we can do to fix the system, we have to do. Thank you.
Next question, the member for Thornhill.
Thank you, Madam Speaker, and I thank the member for her statement. So I was working within the courts during COVID, before, after, and it was remarkable actually, because they went from a system where we filed papers to get things done, and the AG flicked a switch over the course of a few weeks, and they hit the gas, and they modified and they modernized the courts in a way that literally was unprecedented when it comes to speed, and he should actually be applauded for that, because that was absolutely remarkable, and I watched it happen in real time, and I have a real concept of how that was difficult for the legal community. But the courts have been worked throughout the pandemic, and I'm just wondering, don't you think these initiatives were positive? And what would be the alternative had we not been able to modernize the way we have through this new legislation?
Thank you. The member for Oshawa to respond.
I think that there was so much pivoting. That word almost causes stress because we all had to pivot so much during COVID. And so much was learned. So I'm not going to say that these advances or that these, whether digital systems or modernizations, that they were all bad. In fact, it allowed the systems to continue once we got to that point. But why? Why? Talking about tribunals, why is that all that we can do? Why did we have like 11 in-person hearings at the tribunals last year? That's it. That should be an opportunity. Technology should be an option and an opportunity. It should not be the requirement. Even the letter that I read from Jackie, she's 7 years old, she has no idea what to do with Zoom. Why is that her only option to access justice?
Thank you. Next question. The member for Nickel Bell.
Thank you, Speaker. And as the member mentioned, recently our Premier has made disturbing statement about his desire to increase political influence over judicial candidate. You will all remember in the House, when we asked, he said it, and then the next day he doubled down, the third day he tripled down, the fourth day he quadrupled down, that he wants to make sure that judges are people who support the conservative ideas, no matter what people think. There has been many people within the judicial system who says in order for a judicial system to be as strong as possible, it has to be independent of politicians' views. Do you see anything in that bill that will rebuild the public trust after the Premier's comments?
Thank you. The member for Oshawa to respond.
Thank you for the question. And I think disappointingly, the positives in this bill are going to get lost because folks right now have no faith in kind of or have less faith than they did in the direction that the Premier's going when he's doubled, tripled, quadrupled down on appointing like-minded judges. And I'll continue in that vein. The Federation of Ontario Legal Associations have called on this government to depoliticize and return independence to the Judicial Appointments Advisory Committee. And one of the things that they have shared is that the Premier's comments contaminate all of the government's judicial appointments, and that is really problematic because judges who are there based on merit.
Response?
Now it's up to the average Ontarian to guess which ones. If the government is highlighting that they want political appointments, that undermines people's faith, and the government knows that, and yet they're doing it anyway.
Thank you. Next question. The member for Markham Unionville.
Thank you, Madam Chair. As all Ontarians knows that the party of NDP and also the Liberals has a strong passion to protect offenders by defunding the police and also free the offenders back to the street ASAP. While this government is enhancing the Access to Justice Act 2023 would, if passed, make it easier for more victims of crime to sue an offender for emotional distress, and also increasing access to justice for victims by making change to the Victims' Bill of Rights 1995 and its regulation to allow victims to sue for emotional distress and related bodily harm for more crimes, including terrorism, motor vehicle theft, human trafficking, etc. So, what specific policies in this proposed legislation does the member have issue with? Thank you.
Thank you. The member for Oshawa.
Thank you. I love sitting beside the member from Nickel Belt, who very quickly reminded me that this was the government that closed the police detachment in Gogama. And when we're talking about those partnerships that help people stay safe, as the member just raised, how we support victims of crime. This is a government that voted against an NDP amendment in committee that would have required the Attorney General to make a plan to increase the amount of compensation available to victims under the Victim Quick Response Program, which was a replacement, by the way, for the Criminal Injuries Compensation Board, which had its own problems, but victims had access to money that they don't anymore. The amendment wanted to extend the program's deadlines, making it more accessible to victims of historical crimes, and make that program available to eligible victims regardless of their access to other available publicly funded programs. And you said no.
Thank you. Another question? Member for Umber River, Black Creek.
Thank you, Speaker. I thought it was ironic, the government question that just came before. It talked about passion with regards to crime. And ironically, it seems that the government does have passion when it comes to crime, but when it comes to helping victims, all the passion goes out of the room. There's no passion whatsoever. In fact, they got rid of the Victim Compensation Board, and they've replaced it with something that gives far less. So when people become victims of violence, their families can be destroyed. They need help. They're counting on a government, and yet this government has no
Question?
passion to help those victims. Why?
Thank you. The member for Oshawa for a quick response.
I'm not sure. I mean, the government kind of pats itself on the back as being law and order, and yet when it comes to keeping people safe in the first place, or when bad things happen, ensuring that those victims have support, they don't show up. And I don't have a why. I think it's the bumper sticker politics of tough on crime, but we're not strong when it comes to supporting people who are victims of crime, and that's a disappointing thing to say.
Thank you very much.